So it looks like he's on bond for reckless driving in court 14. And that's what probably led him to him here.
That's correct, Judge.
What's he wanted for?
I'll let Amy go ahead and speak to that.
So they double confirmed with the domain jurisdiction this morning for DUI causing death.
Today, we're in Judge Fleischer's courtroom over a dangerous driver. The case was a DUI, occurred in another state, and, according to the report, involved death. The new case is for reckless driving, going 97 miles per hour in a 65 zone, swerving through traffic and tailgating other drivers. Judge Fleischer brings down the hammer. Watch to the very end to see the judge's logic behind his final ruling.
Looks like you're wanted out of another jurisdiction for a DWI causing death.
Yes, sir.
And now we have you here because you picked up a reckless driving. You want me to let you out?
To go to Mississippi. Yes, sir.
It's cute. I don't even know what happened. Let's figure out what happened in the reckless driving.
Judge, in the reckless driving, on August 25th, 2024, officers were patrolling the southbound 7600 block of East San Luis Tollway South. Officers observed a defendant in a black lifted truck traveling at a high rate of speed. The officers captured it speeding for radar at 97 miles per hour in 65 mile per hour zone at the 9200 block of San Luis Tollway. As officers attempted to catch up to the vehicle, the officer observed the defendant cut across different lanes of the highway while failing to signal and cause other vehicles to brake. Officer observed the vehicle following other vehicles closely as it cut.
Don't say anything specific, Judge. I would like to state that this case is out of court 14.
My concern is for public safety.
Here's where things get real. Judge Fleer is laser focused on public safety. Our defendant has already been implicated in a fatal DUI, and now he's driving recklessly at near 100 miles per hour. The judge's concern isn't just procedural, it's about preventing another tragedy. You can see the tension building as the defense argues he wants to answer for it, but Judge Fleer is weighing the potential risks against legal fairness. What would you do in the judge's shoes? Release someone who's admitted to reckless behavior after a deadly DUI? Or hold them to protect the community? Let us know your thoughts below.
He already killed someone on the road with the DWI, allegedly, and now he's driving at near about 100 miles an hour, weaving in and out of traffic, causing others to brake around him. And you want me to set you a bond? Really? I would like hair. It's not going to happen though, man. Not as my wildest dreams, as much hair as I want, I'm never going to get it back. Perhaps I can get plugs, I guess, right?
Judge, if I may, Judge. Judge, so this is a fugitive case. The basis of the fugitive case is for him to answer in the demanding jurisdiction. He had no notice that this case was open. It sounds like the comparison here to Harris County would be a 2B warrant. Nobody notified him of a court date, a court setting. The actual charge is violation of a court order. So I'm assuming they want him to present
I don't
himself.
know that. How do you know that?
There has been no presentation made besides him having a fugitive case. If that's
How long has this case been open, Amy?
Judge, I do not have that information at this time.
And that's the problem with these cases. We don't have the information. So just on the information we have, he's got a fugitive case, violation of a court order. I would ask for him to be allowed to answer for that. Is regarding public safety, he's answering for that in court 15. He's answering for that in Mississippi. This case is just to assure that he makes it to Mississippi to present himself, to avail himself to their requirements. He hasn't had the opportunity to do so. This is the first notice he's had from what he's telling me that he's had to present himself, and he's got a plan in place to do so. He hasn't messed up in your court before. I'm asking for the opportunity for him to go turn himself in. If he messes up, okay, fine. At that point, we have no answer for why he messed up. But right now he's saying he was just made aware of this when he got arrested for this. He wants to answer for it. I'm asking for the opportunity for him to do so.
Your Honor, if I may, I have a newborn son, and I'm trying to resolve all of this. because I can't do this again. I don't need to do this.
Just did.
Yes, sir. I'm
You just,
talking about being away from him. I have
love and appreciate your tenacity. But I think that you are a complete danger to our streets. We lead here in Harris County, the nation, per capita in fatalities related to drunk driving cases. We, if you watch the news, every single day have someone dying on our roads because of someone who is making a boneheaded decision to drive like a freaking maniac. And you, not only do you have this case, but you are charged with killing another in another state while being under
he
the
was
influence.
a very, very good friend of mine, Your Honor. And
Specifics.
people use this.
So does that make it better?
No, sir, it makes it worse.
Right.
Judge, if I may, he is presumed innocent, Judge. He's answering for these charges. He's presumed innocent. The basis of your,
Not finding him guilty, but Ricardo, I think that he's an extreme danger to public society. He's a danger to our roads.
And here it is. Judge Fleischer makes the call, and no bond. This is huge, folks. He's clearly communicating that reckless behavior with a prior fatal DUI just can't be ignored. The reasoning is chillingly straightforward. He doesn't want blood on his hands. This is where courtroom ethics collide with law. The judge's discretion is a protective measure, not punishment. Watch how the defense tries alternatives, signing affidavits, wife driving him, but the judge remains firm. This is a perfect example of judicial responsibility. Who else thinks this is a tough but necessary call? Drop your comments. I want to hear your take.
What we will do is I will hold you at no bond in our jail until you resolve these cases. And at that point, we will notify, or I mean, you've already notified Mississippi that we haven't, correct?
Yes, Judge.
Okay. Hey, Rick.
Judge, he's got no other criminal history. When was this DWI?
Last year,
Last year,
May.
he's had no criminal history since this one DWI and this reckless driving. He hasn't answered for him yet. He's willing to answer for him. He's got no other criminal history besides this. We don't know the specifics of either case. I can't argue for him in either case because I don't know the specifics. He just needs to answer for him.
He's charged with killing another on the road, and now he's driving at about 100 miles an hour. I'm not giving him a bond. You will have to wait to answer until Mississippi comes and gets you. They will take you back if they come, because I don't even know if they're going to come. If they don't come and get you at that point, you know, within the prescribed time, Harris County will release you. But me, I don't feel comfortable giving you a bond because I don't want that kind of blood on my hands. If I give you a bond and you go out there and do something, that's on me. And I have enough trouble sleeping at night as it is. I don't want that kind of blood on my hands.
Judge, can we do any other kind of conditions that you would find reasonable to?
I promise you, Your Honor, my
I know
son
that
is
you're
a
going
lot
to
more
promise me
important
it's
than
gumdrops and tulips and little bunnies jumping in the woods, but I don't believe you.
His wife can drive him to, we could sign a no driving affidavit if that's your concern. As long as it gets him out of jail, he will make efforts to get over there. He will sign a no driving affidavit if that's what it takes, correct?
Absolutely. Yes, sir.
And he's got a plan in place. His wife will take him over there. He works at the refineries. I don't think money's going to be an issue for him. He's a welder, supervisor, something up there, inspector. And so he's got a plan in place. Holding him in jail for 14 days to wait for Mississippi is already punishing him for something that he hasn't been convicted of. We could find other alternatives to allow him to go over there. He could show you a bus ticket. He could.
I'm not giving him a bond card. I'm sorry. You're going to have to wait until Mississippi comes and gets you. And at that point, you can answer the charges, but I'm not letting you out. Sorry. So Jones, what time does court start?
What was that, sir?
What time does court start?
It starts at, I believe, at 8:30, Your Honor. I deal with the mental MHMR.
Try to get here on time.
I will.
Not only that, this is now your second PR bond.
Yes, sir.
If you fail to appear one more time, it's not going to go well for you. Do you understand?
I,
We don't continue to give PR bond after PR bond after PR bond after PR bond. We don't do that.
absolutely.
Okay. You're charged with theft,
Yes, sir.
facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Absolutely.
On February 11th, 2025, at approximately 4:48 p.m., an officer met with the complainant, who is the supervisor for a roofing company. The complainant stated the defendant is a friend and had been working with the company for about a week. The complainant stated that on February 11th at 8 a.m., the defendant was supposed to be at a job but never showed. The complainant called the defendant, and the defendant stated he was at the hospital but would not give the complainant the location of where he was at currently. The defendant eventually met up with the complainant to give him the keys to the company vehicle, and the defendant's employment was terminated. The complainant pulled over and did an inventory search of the vehicle and noticed tools and equipment went missing. The complainant called the defendant and asked where the tools and equipment were, and the defendant stated he removed them so his girlfriend would not take them. The complainant called the defendant multiple times to get the tools, but the defendant blocked his calls and did not answer. The total value stolen was $2,000. The complainant.
Switching gears, now we have a theft case involving Mr. Jones, $2,000 worth of tools and equipment gone, and things get even murkier with conflicting witness names. This segment highlights how even procedural details, like identifying the correct complainant, can become critical in court. Notice how the judge ensures Mr. Jones understands the conditions. No contact with the complainant, no weapons. Legal precision matters because missteps can derail the process. Plus, Mr. Jones is dealing with PTSD and high emotions, showing how personal circumstances intersect with criminal accountability. It's a balancing act between enforcement and fairness, and the courtroom thrives on this tension.
Stated 6 hours passed attempting to contact the defendant, and the officer tried to contact the defendant, and the defendant did not answer. The officer ran the defendant's information given by the complainant, and the complainant positively identified him by a photograph.
Mr. Jones, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of weapons. Do you understand?
I do not, because I don't know who the witness is. What is their name?
Person that you were working for at the construction company that gave you the car.
What was their name, Honor, please?
Tristan Weathers.
Tristan Weathers. Well, on my paperwork, it says Tristan Sanders. I don't know who Tristan Sanders is. So Tristan Weathers and Tristan Sanders are two different people.
I'll file under bond conditions as Tristan Weathers. I'm not sure. I can look. See if there's already.
I was showing the paper. Oh,
Nothing on your
paperwork.
pocket, sir.
Yes, sir. This is paperwork. Say his name
When
on
the
it.
judge requests it, nothing comes out.
It does say Tristan Sanders on the,
It says Tristan Weather here on the complaint.
okay, yes, and I believe that is his name, but on the bond conditions, it's stated as Tristan Sanders.
I don't want you to have contact with this person. Do you understand?
Tristan Sanders, Your Honor, or Tristan Weathers?
Weathers.
It said Tristan Sanders on the thing, so I'm
I'm
confused.
telling you now, I don't want you to have contact with the complaining witness in this case, whoever it may be.
No problem. He's on parole for 60 years. I don't even want to go around the guy. Yes, sir. But on the paperwork, it says Tristan Sanders, and they have that property. But my lawyer, Val Zubini, is going to talk to you or talk to you, represent me. It's just so much stuff, and I'm dealing with, I suffer PTSD PTSD, and I'm hyper. So I'm just trying to take in all the emotions. I'm not mad at you, Your Honor. I apologize for being late to court. I was in the Navy, and I've been in the penitentiary. So I duly apologize.
Relax.
Yes, sir.
No one's going to do anything to you here.
Yes, sir.
The only thing I want is I want my city protected.
Yes,
And
sir.
I'm going to do everything in my power to protect it. I want you to understand that. Do not pick up any new cases.
Yes, sir.
Be nice to everybody that you go around.
Absolutely.
Because if you're not, it's probably not going to go well. Exercise patience
Absolutely.
and things will go well for you.
Absolutely. It has. Thank you.
Do you have the ability to hire a lawyer, or would you like to apply for a court-appointed lawyer?
As of right now, you can give me a court appointed, but I'm going to hire Val Zubini. But Val, I just due to the simple fact, I'm trying to get protective water. That's why I was late last time because my fiance.
Just don't talk. You have the right to remain silent. Anything you say, they're going to use it against you. So it's best not.
That's
I'll
cool.
provide you a lawyer today.
It's true.
Tell everything that you want to say to the lawyer, and then they can come and talk to me if they need.
Yes, Your Honor.
Okay? Just don't miss any court dates
Yes, Your Honor.
and stay in contact with the lawyer that we give you.
I have a question though. So the last time I came, I was my fiance.
You haven't come here.
Yeah,
This is the first time that you've come here.
correct. I'm incorrect. I came last time at 12:30 because my ex-fiance had my cell phone. I talked to one of the ladies in the back, and I talked to her.
Hold on, Mr. Jones. I don't want you to say anything else. Let me give you a lawyer.
This is my second. I don't want you to know this is my second time coming. I came to court. I just came late.
It's not a big deal.
Yeah, I know.
Let me give you a lawyer. Just hang tight for me, be patient, and then we'll find you someone, okay?
No problem. Thank you, sir.
Don't leave until you sign our bond conditions.
I'm not going anywhere, sir.
Thanks. Not yet. We need them to file. Oh, I already have them. I got them.
I talked to you last time. This is what I talked to right here.
We just need you to sign a reset real quick. You're good?
Yes, Judge.
Yeah, please.
Come back. We're downstairs.
I was gonna reset it so I can look at everything. That's all.
I don't know about waiving it though.
No, that's fine.
How old is this case? You know? It's the case that we just had on Mr. Jones.
Okay. This is the new theft is from February 11th, 2025.
The new, how many cases is it?
Sorry, I thought that he had multiple. No, the theft is from February 11th.
Mr. Jones, come up. I'll waive it. I thought it was old. It's not an old.
It's up to you. I don't care what we're doing. Whatever you want to do, Jeff. Who wants to be here?
So, Mr. Jones,
Yes, Sean.
I've given you a lawyer.
I thank
Okay?
you.
So I usually waive people's appearances, meaning that you don't have to waste your time coming to court, but you have to stay in touch with him. If he tells me he can't get a hold of you because you're not answering his phone calls or text messages, I'm going to issue a warrant. All I'm asking you to do, don't get in trouble and stay in contact with him. That's literally all I'm asking you to do. Don't get in any trouble.
Yes, sir.
You understand?
Yes, sir.
All right, we're good. He can't leave yet because he has to sign bond conditions. As
Okay.
soon as he signs it, then we'll let you go. Okay, they're creating bond conditions. So you promise us that you're going to behave. We'll have you sign it. And then after that, you'll be free to
I'm
go.
not a better version of you, Honor. It's just a little bit on paper. I changed my life.
I got you, man. We'll
Yeah.
trust you.
I've
That's why
been
you're out and about with us now.
doing a lot for the community.
Just stay in contact with him. Okay?
Give me my number once we're done, okay?
Can I tell you something though? I actually was on the news last year with Kim Judge Nimmy. They did a story on me in Channel 2 News. I was on the news. They used my story for the company I work for change for mental health.
That's great.
And I was on the story for Kim and Judge Nimmy and Carnival. So I've made a bunch of changes. This is a mistake, and I just get so emotional when it comes to it. But I apologize.
Don't, because remember, they can use anything that you say.
I got you.
Just,
I got you. No problem.
Let me look at everything.
No problem.
We'll figure everything out, okay?
Thank you.
Okay.
Judge.
all right, so take a seat, but don't leave until we let you go.
All right, have a seat.
Thank you, Mr. Jones.
Okay, and then I got one more judge. This is gonna be Vanessa Gonzalez. They're still trying to get a RIP call done, so there's not a RIP done yet. So I'm just gonna reset that. It's 189 days old, that's why.
I mean, how long? We're now 3 months waiting for a RIP?
Right, and we've attempted to contact him multiple times.
People don't want to be found, or they want to be found. I'll give you a week. After that, just proceed as if without, you know? Okay?
And she is here. Can I waive her appearance?
Yeah.
Thank you, Jeff.
Your Honor, we have a case that's not on docket today, but she's got a warrant. They filed on her last month for a case that happened in August. And she wanted to turn herself in. The case number is 2553 536. Brianna Beck.
You are Brianna Beck.
Yes.
Ms. Beck, you are now charged with theft. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Judge, can I get the case number, please?
255-3536.
3536?
Ready?
Yes. On December 17th, 2024, an officer reviewed an offense report of a theft on September 17th, 2024. According to the report, the complainant reported that the defendant, known to the complainant by name and site, stole 2 espresso machines on August 9th, 2024. The complainant stated the defendant committed the theft at 3 other store locations. The officer reviewed documents that there were theft incidents at 4 home goods locations. The first incident occurred outside of Harris County, Texas. The second incident was investigated by the Harris County Precinct 4 Constable's Office. The third incident occurred on August 9th, 2024, where the defendant and an unidentified female entered the home goods and entered the line to make a merchandise return. Once in line, the defendant ran toward the back, where she selected 3 sets of sheets and then walked to the front of the store and rejoined the female in line. The defendant then placed the sheets on the counter and provided the cashier with her state ID. The system denied the non-receipted refund due to excessive returns without a receipt. The merchandise was then returned to the defendant. The defendant and the unidentified female then left the store, passing all points of sale without attempting to pay. The value was $599.99. The fourth incident occurred on August 9th, 2024. The defendant arrived alone at another home goods location and proceeded into the store with an empty shopping cart. The defendant selected 2 espresso machines and then walked to the front of the store and passed all points of sale without attempting to pay, and the security sensors went off. The value was $999.98. The officer reviewed the surveillance footage from the third and fourth incidents and compared them to the defendant's previous booking photo, and they were a match.
All of Marshall's Home Goods? Is that what it is?
Yeah.
Okay. She's on bond for a theft. She's on bond for a gun case with us now. Where's the first theft?
The first theft is from a Walmart judge. $121.
Ms. Beck, I'm going to find that there's probable cause to go forward with the case, and I'm going to tell you now, I will do everything in my power to protect every person, place, thing in this county. And if I have to put you in custody and make your bond $50,000 because you continue to become a danger to our city, I will do it in a heartbeat. Do you understand me? I'm ordering you not to go to any Walmart, any Marshall's Home Goods, in anywhere. And I'm going to put a GPS monitor on you so I know where you are at all times. You are not to consume alcohol or illegal drugs.
Buckle up, because this is a textbook example of bond conditions used to enforce accountability. The judge isn't just setting a dollar amount. We're talking GPS monitoring, workplace verification, and drug testing. This isn't arbitrary. It's a strategic framework to ensure the defendant doesn't continue a pattern of illegal activity. And notice how the defendant's own behavior, turning himself in, showing up voluntarily, gets weighed against the seriousness of prior offenses. In court, the combination of proactive compliance and judicial oversight can make or break outcomes. This is why lawyers always emphasize compliance with bond conditions. They're not just rules, they're lifelines.
And I'm sending you now for a test so I know what, if anything, is in your system. You're to test, and then you're to come right back. Do you understand?
Yes, sir.
Do you have a job at this time? What do you do for a living?
I'm a reservationist.
Okay. I want proof that you have a full-time job because that is now a condition of your bond as well. I want to make sure that you're working full-time as well.
And Your Honor, the defendant is also a complainant in this court as well. I need to bring up, we've reassigned these cases so that we can deal with it, and so it's on separate prosecutors. Like, I have the other defendant's case assigned to me, and Abigail is assigned this case.
I mean,
She's
you
listed
guys
as So she is listed as the complainant in a separate case also in court 5.
In what regard?
So she,
Like in an assault or something like this of this nature?
yes, it's an assault, Your Honor. And to.
Okay, so you divvy it up how you want.
Yes.
Yes.
Because I don't want her to pick up 4th case.
Right.
No, we just want to
Sure,
make you
that-
aware, Your Honor.
Yes.
I'm also ordering you not to be in possession of any weapons. Do you understand? These are your bond conditions. You violate these conditions, I'm going to revoke all of your bonds and I don't understand why you're having attitude.
I don't.
You have now 3 cases. You're rolling your eyes as if you have some kind of, you need to talk about bond. What do you suggest as far as a bond in this case, on the newest theft case?
We would suggest a surety bond on the case, Judge, and leave it up to your discretion in terms of amount, but I don't think a PR bond would be appropriate here.
Well, if you do, make it a surety bond, we'd ask for it to be, low. She did show up here on her own volition today. And I think she's, at least for today, showing the right attitude about how to handle this from here on in.
Set your bond at $2,500. Cash surety. No more PR bonds. Do you understand? I want to send her for a drug test right now. So Fleisha,
Judge, I can't send her until the bond has been posted, or else they'll take her into custody.
okay, then I'm going to give her a PR bond for now because I want to send her right now.
Yes, Judge. I'll still have to wait till that trial starts.
Yep, go for it. Okay, I'm going to set the bond at $2,500. I'm going to give her a PR bond because I want to send her for a test now. You were to test and then you're to come back. Do you understand? Not leave until you sign our bond conditions. Please take a seat.
Do I have to be back here when she returns?
No, I'm not. I want to know what, if anything, is in her system, but I want proof within a week of today of full-time employment. Okay. And then depending on what happens with the test, when we come back in a week, we'll talk about how to go further. Okay. Thanks.
You see it.
You too. What's up? I like your tie.
Thank you. Likewise. Your Honor, I have on today's docket, Mr. DeTravius Bell.
Bell. Okay.
Mr. Bell was in custody, so he's under the bond conditions.
He's out.
He's out, yes, Your Honor.
So he's out on bond for an aggravated assault now, right?
Aggravated sexual as well. At Fort Bend, yeah, so he's on, stat the further adjudication out of Fort Bend County, Your Honor. And then he has these 2 new charges that he picked up. I thought you were saying in Harris County.
No, I'm just curious, what all does he have open at this time?
So it's just the Fort Bend County case, Your Honor, and I'm happy to apprise you of the facts and make sense.
No, I'm just, can you apprise what happened in this case, please?
Yes, so on February 24th, 2025, the officer was dispatched to a burglary of a residence in progress call in Harris County, Texas. The officer made contact with the complainant, the property manager, and the complainant stated that she was working around 11:30 a.m. and received a call from a witness who was working the pool and notified her that the defendant had kicked down the front door to a unit and the defendant had entered the unit. The complainant stated the defendant had been evicted from the apartment that morning and was given a reasonable amount of time to gather their stuff and leave. Once the complainant confirmed with the defendant that his stuff had been secured, the complainant locked the unit. The complainant stated the defendant still came back and kicked down the front door and entered inside to grab items. The damage was $650. The defendant stated that he was at the corner store near the apartment and that he was not in the unit, nor did he kick down the front door. The defendant stated that he was there to help with his cousin and did not do anything wrong. The officer observed a writ of possession taped to the door, stating on February 24th, 2025, the tenant was served and a trespass warning was attached to it. The defendant gave the law enforcement officer a false name, DeTravius Bell, date of birth, March 26, 2000. Officer asked multiple times, to which the defendant confirmed his name was correct. And the defendant was later ID'd via APHIS to be DeTravius Bell. revealing the defendant to have an outstanding out-of-county warrant out of Fort Bend for failure to appear for the aggravated assault with a deadly weapon.
Can I speak, Your Honor? My understanding of the facts, without saying this is what he said, but it was him and his cousin. The officers were responding to a description. His cousin also has dreads, Your Honor. They were moving out of the apartment that day. He took a break to go to the store to go get an iced tea. And his cousin found out that they had locked the door on him or whatever. And his cousin is the one who kicked the door in. But they both have dreads. He was coming back to the location. If you notice, he wasn't at the location when they detained him. He was coming back to the location. They stopped him and asked him his name. And because he had this out-of-county issue in Fort Bend County, he gave a different name because he wasn't sure why they were stopping him. But he wasn't there. He's totally caught off surprise with all of this. And it's of note that he was residing with his cousin and they'd just been evicted that morning. So they were moving their stuff out. So the conversation reads as if, or the DIMS reads as if it was all with him. It's not reading that it was with two different people.
Can you run the NCIC? My concern is that he has an open aggravated assault with a deadly weapon. Is he on probation or is it just an open case?
He's on probation and it was an open warrant for failure to appear.
Which is why we're
You
clearing
realize that you're on probation for an extremely serious case that could land you in prison for like 20 years. Do you realize this? No, I don't think you do. You can go to prison for a very long time. And it's a 3G offense, meaning that whatever you get sentenced to, you have to do half the time before you're even eligible for parole. So if they sentence you to 12 years, you have to do 6 until you're even eligible for parole. Do you understand? You must live like you have a freaking halo over your head because you've now picked up these 2 cases. Well, I don't even know if you're on probation, but if you are, and now you've picked up these 2 cases, Fort Bend isn't like Harris County. Brazoria isn't like Harris County. Brazos isn't like Harris County.
Now, let's talk about probation consequences. Travius Bell thought he could skate by, but Judge Fleischer lays it out clearly. This is serious business. Probation violations, felony probation, aggravated assault. These aren't minor offenses. And here's the kicker. 3G offenses mean you do half your sentence before parole eligibility. The judge even sets tangible expectations: employment or school enrollment, GPS monitoring, no late-night wandering. This segment highlights the reality of the legal system. Choices have consequences, and proactive engagement with probation conditions is essential. Pay attention, because this is a cautionary tale for anyone navigating probation or high-stakes criminal charges.
They are a lot tough. Do you get my drift? What are you doing with yourself now?
I currently had a job. I lost a job when I went to jail, but I'm trying to get back to strict will now.
People who have too much time on their hands become self-destructive. Mr. Bell, I don't want you smoking anything. I don't want you using alcohol, and I'm going to test you to make sure that you're not. Do you understand? And I want you back here in 2 weeks to show me what you are doing with your life, either a job or actively enrolled in school. And if you're not doing anything, it's really not going to go well for you. Those are probably conditions that are on your felony probation as it is. Do you understand? So I'm going to ensure that you're not going to fall through the cracks. Get my drift? So you either do it the right way or you're going to end up with me.
Okay, got it. You're perfect.
I'm going to put a GPS monitor on you so I know where you are and you're not to go out in the middle of the night. Do you understand? And I want you back here in 2 weeks to show me what you have done. I want to see like 25 applications, or you must be actively enrolled in school. Do you understand? Okay, got it. Thanks, Doug.
To wrap up today's session, here's the professional breakdown. Judge Fleischer denied bond in a high-risk DUI and reckless driving case to protect public safety, while simultaneously managing multiple theft and probation cases with strategic conditions like GPS monitoring and drug testing. The overarching theme? Judicial discretion and public protection are paramount. Defendants have a chance to comply and redeem, but the consequences for reckless or repeated behavior are serious and immediate. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. You won't want to miss what's next in this court.
Judge, 10.
Yeah.